This is an overview of land law before we start on the proper syllabus. It's a very short recording. It's just to introduce you to land law and give you an overview. There's no need for you to take any notes. There's no need for you to memorize anything that I'm telling you now. Just listen and try and take it in. So the unique thing about land is that each piece of land can hold many different interests owned by different people. And what I'm trying to do with this recording is to show you all the different types of interests that one piece of land can hold. So we start with the piece of land in the middle, and that's Blackacre. And Blackacre is owned by A, let's say. Okay, so A is the owner of Blackacre, and today, because all of land today has to be registered, the title to the piece of land has to be registered. A is called the registered proprietor. That's the technical term for an owner of a piece of land. So A would be called the owner, or more properly, the registered proprietor of Blackacre. So let's say A bought Blackacre, but not all with his or her own money. So A owns Blackacre. A has an estate in Blackacre. So in land law, there are individual rights in land could be called an estate or an interest. Whether it's an estate or an interest, we will learn in the first chapter when we look at the different rights and in land, and statute will tell you whether a particular interest right in land is an interest or an estate. Now, if it's a freehold estate, it's called an estate. So A's right in Blackacre is called an estate. So we know that A owns a right in Blackacre, right? But A didn't pay for Blackacre all using their own money. So let's say B, who's A's partner, contributed 20% of the purchase price. Now, B's name is not on the title register. B's name is not on the deed. B merely contributed money towards the purchase of Blackacre. So because B's name is not on the register, not on the deed, B is not a legal owner of Blackacre. However, equity recognizes that B has an interest in Blackacre, and this interest that B has is more properly called an interest behind a trust. Now we're going to look at interest behind a trust in more detail in both land law as well as in equity and trust. So I'll leave it there for now. But the situation now is that we know that there are now two people who have rights in Blackacre, and that's A as well as B. B's right is recognized not at law but in equity, and B's contribution of 20% practically means that if Blackacre was ever sold, B would be entitled to 20% of the sale price, the proceeds of sale, right? So now we have two people having an interest in Blackacre. Now let's say when A bought Blackacre, A borrowed money from C Building Society, and he borrowed 30% of the purchase price from C Building Society. So C Building Society would have lent the money to A, but in return, C Building Society retains an interest in Blackacre, and this interest is called a mortgage. So now we have three parties having an interest or an estate over Blackacre. That's A, B, as well as C Building Society, whose interest is technically called a mortgage. And mortgage or mortgages is a topic that we will cover in land law in due course. Yeah. Now, moving on, A's neighbor, one of A's neighbors, D, owns Redacre. So D's land is called Redacre. So let's say A and D came to an agreement where A granted D a right of way, and that's denoted by the two red stripes that you can see over Blackacre. So D was given by A right of way which crosses Blackacre. This right of way is maybe it's a shortcut for D. So D takes this right of way as a shortcut to get onto the main road. And this right of way is technically called an easement. So we know now that another party also has an interest over Blackacre, and that's D. And D's interest is called an easement. Easement is another topic that we will cover in due course within the syllabus of land law. Now, what else? Let's say A's neighbor on his other boundary, E, the owner of Whiteacre. Yeah. So one day A and E executed a deed. What a deed is, we're going to look at in due course as well. So they executed a document whereby A promised not to build near the boundary between Blackacre and Whiteacre. So this would usually be done for some consideration. So E would have paid A sum of money, and in exchange A covenanted. A covenant is a promise made in a deed. So because they executed a deed and A promised not to build near the boundary, what we call this particular right in land is a covenant. And because this covenant prevents A from doing something on his or her own land, it's called a restrictive covenant. And so now we know there's another party, a fifth party, having an interest over Blackacre, and this interest is called a restrictive covenant. So if A ever tries to build near the boundary between Whiteacre and Blackacre, E will have rights, he will have remedies, he will be able to go to court and possibly get an injunction to stop A from building in breach of the covenant. And the final, sorry, before I move on, restrictive covenants, or rather freehold covenants, is another topic that we will cover in land law. And the final one would be F. So let's say A doesn't want to live on Blackacre anymore, but he doesn't want to sell it. So A decides to grant a lease, and the lease is granted to F, and it's a 20-year lease. So F has now been granted a 20-year lease over Blackacre by A, which gives F a leasehold over Blackacre. So leases is another topic that we will cover. So for the next 20 years, F will have the right to live on Blackacre by virtue of this lease. A lease is a right in land, and it's actually called an estate. You will see when we get to it that a leasehold and a freehold are both estates in land. Everything else that we've looked at, the mortgage, the easement, the covenant, the interest behind a trust. These are called interests in land. But the freehold and the leasehold, A owns the freehold of Blackacre, so A's right over Blackacre is that of an estate. F now has a 20-year lease over Blackacre, so F also has an estate over Blackacre. And obviously, D, who owns Redacre, and E, who owns Whiteacre, both respectively have estates over their own property. So this is an overview. Like I said, there's no need, don't panic if you find the technical terms confusing. Land law is very technical, so you will get used to it as we proceed with the syllabus. And in the course of my lectures, every time I come across a technical term, I will explain it. If I forget or it's missed out, then as you know, we will see each other in seminars, so you can always make a jot down any terms that you don't understand and bring it along to the seminar, and I will explain everything. And this is it. That's the overview of land law. I hope you found that helpful.